This feature story we bring before you all under the background of the Rashtriya Swayamsevak Sangh, RSS mouthpiece, organizer, calling the attention of the Modi government that the fact that it is not the Waqf board, but the Catholic Church of India, which is the largest landholder in the country. Even though, after protest form, the political parties, the article has been removed from the website, but its hidden agenda is more or less clear now. Under these circumstances, there is a fear growing in the Christian community regarding the properties owned by them and the recent orders by the courts, which appointed administrators to run the church organization in South India and North India. We bring before you all to understand the working of the Catholic Church and the administrative setup. This story also will analyze the legality of the canon law church law and the provisions of the Indian and some of the court judgments that can affect the imminent law to govern the church properties in India. The article says that the Catholic Churches of India is owning more than 7 crore hectares, which it said is the largest non-governmental landowner. According to Yale Climate Connections, one of most important research organizations on climate change, says in its report that the Catholic Church owns 177 million acres of land across the globe for its churches and institutions, as well as owning farmland and forest land. How does the church works in India? It is to be noted that Vatican is the smallest country, and being member of the United Nations, it has ambassadors in almost all countries. In the same way, it has an ambassador in India and is called nuncio in Latin. Vatican State is running the Roman Catholic Church directly through its embassy in India. The Vatican State has direct control over each diocese registered as a society in India. According to canon law, for the purpose of fulfilling the religious needs of members of the Church, Vatican appoints bishops in each diocese who takes over as the president of the registered societies in India. They continue to be presidents of the societies till the age of 75 or till their retirement. All the bishops directly report to Vatican State authorities through its embassy in Delhi. There is no system in India to address even the grievances of its members regarding the administration of religious and temporal matters. All such matters are dealt by Vatican bureaucracy through the embassy. All the properties are registered in this societies or dioceses. To sell off properties, dioceses are supposed to get the permission of the Vatican authorities. So in such conditions, can the government control the Catholic Church properties? All the Catholic Church properties are owned by the dioceses set up by the Vatican State, which is a member of the United Nations. We need to correctly understand the charities from the point of Indian legal system. India has evolved a series of legislations which address the field of voluntary non-profit sector in different ways. The Article 19 of the Indian Constitution gives right to freedom to form associations or unions. Various legal provisions prevalent in the country emanate from the aforesaid article of the Constitution. The Article 43b of Indian Constitution states, "The state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies." But all these are subjected to reasonable restrictions, as in Article 19.4 of the Constitution. All the state laws to help smooth functioning of the charities are based on above-mentioned legal aspects. The personal laws of minorities and majorities are not applicable to laws that govern the charity organizations. The donations and excess income generated in these institutions are governed by the law of this country, not by the personal law. It has been made clear in Canon 22 and Can 1284/2 that the Church has to follow the civil law in administering the property's income generated from all sources. It may be worth mentioning here that the Canon 1267 clearly mandates that even the gifts or donations received by church personals in their personal capacity too has to be accounted. Moreover, the Honorable Supreme Court in Molly Joseph versus George Sebastian, 1996, 6 SCC 337, emphatically settled. It stated that any dispute that might arise from the forceful implementation of canon law made by the sovereign kingdom of Pope shall not override the laws of the sovereign India. Considering all these facts, we need to wait and see what is the future waiting for the Indian Catholic churches in the days to come. Their administrators running the churches in India through the court ruling. So what